Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamblett Kerrigan. I've been practicing law in New Hampshire for approximately 39 years and in the Commonwealth of Massachusetts for approximately 28 to 29 years. And I'm going to be addressing in either of these states how to deal with your sibling that is still in the house of your parents' house that you want to sell. So we're going to be talking about that in today's vlog. So first and foremost, you're in a situation where your parents have passed, it's troubling, and you have a sibling that's still in the house. Maybe they're in their 50s, 60s, and they've been living in the house. Maybe they came back after a divorce, whatever the situation is, but they're still in the house, and they have an they have an interest in the house, perhaps, and you have an interest in the house, and you're supposed to be selling it. So let's talk about the various issues that come about in this and how you deal with it. First is, how is your parents' estate plan set up? If your parents are set up where the estate plan was where the property itself is in a trust, then the trustee, if you're the sibling that's the trustee, is the owner of the property, and that property is being, and you're planning on selling it to distribute to all the siblings or all whoever is supposed to be the beneficiaries of the trust. The sibling, the brother or sister that's living in the property, while they have a beneficial interest in the property, they really are in the trust, they arguably should get an eviction notice. So, and I've dealt with those issues in circumstances where we do an eviction, and if they say, look, I have a title to the property, just having a pure equitable interest shouldn't be enough under the landlord tenant statutes to say, look, I have a part interest in this property. If you have a beneficial interest, is enough for argument for them to make. So I would move forward with it, trying to do an eviction, certainly trying to negotiate with this person, and if they have an attorney, that's helpful. Sometimes this person might be have capacity issues, mental capacity issues. That might be one of the reasons why they're in their 60s still living, or 50s still living with their parents. So they might have had some medical or mental conditions, physical or mental impairments that it might impact them. All those issues, you talk with your counsel, and you try to, if they have counsel, try to work that stuff out. But going through the eviction process during a period of time while you're negotiating makes sense, because the person has been living there all their lives and they don't have much options that they're thinking about. So you want to push that issue. Certainly, if they have the ability to to buy out the others, and that is a realistic interest, and often they say they can, but they can't, then in that situation, that can be a win-win for everyone, because you don't even have to involve brokers. But absent that, you want to address getting them out as quick as possible, and getting the legal process going as quick as possible. So while you can negotiate, you're not starting fresh when the negotiations fail, which in my experience, they will, without pushing the point aggressive, politely, but aggressively. So that's the situation. If you have a trust, if you just have a will, and everyone's getting a piece of the property, in New Hampshire, a solvent estate, meaning that there's no creditors that need to be paid, such that there's nothing left in the property. The property is going to be going to all those people, and one of them can maybe claim an interest in that property. And if they want to claim that interest, you can do what's called a partition action. Or you might be in a situation where mom and dad, just before they died, decided to deed the property, or put it in joint tenants' right survivorship with their children to avoid probate. In that situation too, they have title to this property and you can't evict. You have to go through what's called a partition action. New Hampshire and Massachusetts both have partition actions. And my experience in both courts is the judges do expect the property to be sold in that situation, absent somebody being able to buy out the other person. So that's a way to force them. Just have the person that's living there saying, "Oh, mom and dad always allowed me to live in here," unless the estate plan gives them the right to be there and stay for their lifetime. If it doesn't say that, then the courts generally will force that issue, and you want to force it with a partition action if they have a title interest, or an eviction action if they don't have a title interest, like in a trust or something. They could also be in a situation where they've actually, under the estate plan, the parents have addressed the issue and said, we've taken care of Junior for all these years, and we consider that to be the contribution of his inheritance, so we're not providing any more of an inheritance to him, so he's not even getting any portion of the real estate. In that situation, you're doing a straight eviction as well. But in those circumstances, you want to move on these things fast. If you are doing an eviction in New Hampshire, just don't, even if you think that the person owes you money on the first page of the landlord-tenant writ, I've said this in other blogs, don't check off the box for like $1,500. Don't do that. Just go for the straight eviction. Partition action, just go for the partition. You're asking for the court to sell the property and divide it in accordance to the terms of the trust, or in the terms of the intestate rules, which is, the intestate rules are the rules that happen when you don't have a will or a trust. So if your parents didn't have a will or a trust, there's certain rules that happen by statute that says this is what is going to happen, and those would be the way that the property should be dispersed. I'm attorney Dan Marr. I've dealt with this for quite a few years, decades, and I'm happy to help if the opportunity arises. I'm at 603-883-5501. You can also reach us at our website of nashualaw.com. That's Nashua one word, .com. Check my vlog on my bio, and you can check out all my vlogs. I've been doing weekly vlogs for a number of years, all by different topic. Happy to help you if the opportunity arises. Again, Dan Marr, 603-883-5501. Thank you.